Good morning, everyone, and thank you for joining us for the Medical Board of California Panel B meeting pursuant to SB 189. This meeting is being conducted via WebEx. If you're having difficulty hearing the audio of this meeting, it could be because the device you're connecting with has bandwidth limitations. If you do have difficulty hearing the audio of this meeting using your device, please click the ellipsis button at the bottom of the WebEx application or the audio and video menu item at the top of the WebEx application, and then select Switch Audio. You will see an option to call in and will be provided with a phone number, access code, and attendee ID that can be used to connect to the meeting audio via phone. Using the information provided, it will automatically disconnect your device's audio and connect your phone to the name you joined the meeting with. By using this method, if you're having audio problems with your device, this will allow you to still participate and hear the audio of the board meeting. Please see the instructions on how to connect link on the last page of the meeting agenda for step-by-step WebEx instructions, including screenshots. Thank you, Dr. Thorpe. You can now start the meeting.
Thank you, Sean. Good morning, everyone. I want to just say, first of all, I want to apologize to the Honorable Judge Van Rooyen and Council for our delay. I know your time is extremely valuable, and we want to value that. Unfortunately, we had difficulty with a number of connections, so we want to apologize for that. But we will proceed here. I want to welcome you to the first meeting of Panel B for the year 2023, and thank you those panel members who are present today. It's as usual, it's always an honor to serve with you, and appreciate your service. So we'll call the Panel B meeting to order at 10:19 on February 8, 2023. Andrea, if you will, Andrea, if you'll call the roll so we can establish a quorum.
Dr. Hielser?
Here.
Dr. Thorpe?
Here.
Dr. Mahmood?
Yes.
Ms. Young is absent, and Mr. Brooks is absent. Ms. Lawson?
Here.
We have a quorum.
Thank you, Andrea. At this point, without delay, we'll proceed to the second order on the agenda for today. I would, just as a matter of business, I would point out to the panel, the panel agenda was updated at the last minute late yesterday, so you make sure that you have the latest SharePoint version of the Panel B materials, because three additional cases have been added. Multani, Tipton Healy, and TRAN. A different TRAN, young TRAN. So if you will just make sure that you're aware of those, and we can work on those in closed session. Okay, Judge Van Rooyen, sorry.
Good morning, Dr. Thorpe, and good morning to the board members. My name is Judge Van Rooyen. I'll be conducting the hearing or the oral argument today. Let me just make sure, first of all, that the attorneys, the Deputy Attorney General, as well as I think Mr. Garcia, counsel for Mr. TRAN, have you been promoted to panelists, and can you hear me clearly?
Yes, Your Honor.
Terrific. Was that Mr. Garcia?
That was Jason An, Deputy Attorney General.
Oh, good morning to you, Mr. An. Thank you so much. And Mr. Garcia, can you hear me and clearly?
Good morning. Yes, this is Albert Garcia. I can hear you clearly. Thank you.
Thank you. Although I hear your audio is a little bit unclear to me. There's a little bit of a static.
That would be, but maybe I get a bit closer. I don't know. That any better?
Nope. No, you're still quite unclear. I'll let you just quickly work with Mr. Eichelkraut and see if you can fix that so we can hear you clearly before we proceed.
Mr. Garcia, it almost sounds like you have a headset plugged in on your desk or something like that. Or you sound very distant from your computer, although it looks like you're very close to it by your camera. But
I don't have anything plugged into it.
Okay, I'd recommend, yeah, because it is quite faint. I'd recommend going up to that audio and video menu up at the top and go
Okay.
ahead and click switch audio.
Okay.
And there's a call in that you can hit that button and you can dial the information yourself, or you can say call me and you can type in your phone number there and have it call you on your desk line, or on your, if you have a speakerphone there in your office or even a cell phone or something like that, it'll move your audio through that so it'll sound clear.
Okay, I'll call in.
All right, and while you do that, let me check with our court reporter, Ms. Schurmeister. Can you hear us clearly?
I can, and it is very good to see you again.
Nice to see you as well, Ms. Schurmeister.
And when Mr. Garcia's dialed in, we should see the little icon next to his name change from a little headset to a phone. There it went. So, Mr. Garcia, you'll still use the mute and unmute controls on your computer screen, and that will mute and unmute your phone. So don't worry about pressing mute or anything on your phone there. But yeah, can we hear you now?
Can you hear me now? Is that better?
Much better.
That's sound clear.
Okay, then I'll use the phone then.
Yes, that's very much better. And just speak up as much as possible. Now it's just your volume is a little low, but I think that's easy to address as we proceed. And then last, I just want to...
sorry, Judge. Mr. Garcia, if you have a speakerphone on that phone, it will work just as well, probably.
Hold on 1 second, please. How about that? Can you hear me?
I can hear you fine. Again, just speak up as much as possible. Just that'd be great. And then I think your client, Dr. Tran, is on as well. I don't know, does he plan to give us a statement later on? I just want to make sure we have his audio as well before we get started.
Yes, I believe he will give a statement, yes.
All right. Dr. Tran, can you unmute yourself and we'll just check that you can hear and we can hear you clearly?
Yes, I'm here.
Terrific. Thank you so much, Dr. Tran. I appreciate it. For now, you can mute yourself, but when there's the appropriate time, I'll let you know and you can unmute yourself again. Perfect. Other than that, I'll just let the court reporter know. I'll try to be as clear as possible when we go on and off the record, but if there's any concern, just let me know, and clarifying is always better than guessing. So thank you so much. Is everyone ready to proceed for us to go on the record, Mr. On?
Yes, Your Honor.
What about you, Mr. Garcia?
Yes, Your Honor.
Terrific. Let's go on the record. Ms. Schurmeister, you ready as well, correct? Ms. Schurmeister, are you ready for us to go on the record?
Sorry, I was muted. Yes.
No, that's fine. I just want to make sure. Thank you. All right, let's go on the record. All right, we are on the record before the Medical Board of California, Department of Consumer Affairs, State of California, in the matter of the first amended accusation against Phong Hung Tran, MD, spelled P-H-O-N-G, Hung, H-U-N-G, Tran, T-R-A-N. This is Physicians and Surgeons Certificate number G74233. The Medical Board of California's case number is 800-2016-019951. The original OAH case number for this matter is 2019-040-901.1, and then the new OAH case number assigned to this oral argument is 2023-010-308. Today is February 8th, 2023. It's approximately 10:27 a.m. This is the date and time that was set for the oral argument in the amended order fixing date for written and oral argument after Superior Court remand. Pursuant to that same order, we are conducting the oral argument via WebEx video conference. My name is Wim van Rooyen. I am an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over the oral argument today. We have already taken a roll call off the record, but since we're not on the record, let's make sure we have a quorum. Could I please have each panel member identify themselves for the record, please?
Richard Thorpe,
James Helser,
Asif Mahmood,
Christina Lawson.
Thank you very much to the board members. I do find that we have a quorum present. And now may I please have the appearances of counsel, please starting with the Deputy Attorney General.
Good morning, Your Honor, and good morning, members of the panel. Jason Ahn, Deputy Attorney General, on behalf of the complainant.
Good morning to you, Mr. Ahn, and then on behalf of the respondent, please.
good morning. This is Albert Garcia, appearing on behalf of the respondent, Dr. TRAN.
Good morning to you, Mr. Garcia, as well as to your client, Dr. Tron. So we are here today pursuant to the Superior Court of California, County of Sacramento's judgment on the petition for writ of administrative mandate in the matter of Phong TRAN, MD versus the Medical Board of California, case number 34-202-80003582, dated January 29, 2021, and the medical board has accordingly requested written and oral argument in this matter. The board has invited particular discussion of how the board's disciplinary order should be modified in light of the court's decision. The following process and time limitations will strictly apply to the oral argument this morning. First, the respondent will have an opportunity or respondent's counsel will have an opportunity to make an opening argument for 15 minutes. Thereafter, the Deputy Attorney General will have an opportunity for an opening argument, which will also last 15 minutes or up to 15 minutes. Then the respondent will have 5 minutes to give a closing argument, followed by the Deputy Attorney General also being afforded 5 minutes for a closing argument. I'll remind the parties that these time limits will be strictly enforced. I will try to give you a 1-minute warning as you come up to the end of your time, but again, you are responsible for tracking your own time. The argument shall be based only on the existing record and shall not exceed the scope of the record of the duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. Either I or any panel member may ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral argument of all counsel, I will offer the respondent physician, Dr. Tron, an opportunity to address the panel. If Dr. Tron elects to address the panel, I will place him under oath. After oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will be receiving it in the mail sometime in the future. And again, I just must emphasize that the arguments must be based on the existing record and that no new evidence will be heard. As a reminder, the board has already had the benefit of reading your briefs. So with those admonitions, we can proceed directly into the arguments. Are you ready to proceed first, Mr. Garcia, with respondent's opening argument?
Yes, I am, Your Honor.
All right, thank you so much. You may begin. Your time starts now.
Dr. Thorpe and members of the panel, I know you have read the record and the written arguments submitted by Dr. Tron. I do not want to engage in legalistic argument here, but there is a threshold legal issue. In fact, the judge has touched upon it in his remarks that has been presented for determination. And its resolution will dictate the nature and scope of this proceeding. I know that there are two attorneys serving as public members of the board, although one of them is not present today, who are on this panel. And of course, we have an administrative law judge also present. So before I launch into the substantive part of my argument, I respectfully request a ruling on the preliminary question briefed in the written argument of whether the decision of the board issued back in December of 2020 with an effective date of January 29th, 2021, has been set aside by the judgment of the Superior Court, rendering it null and void. And if so, whether Dr. Tron is entitled to a new plenary hearing on the accusation. In response to the judge's remarks about the scope of the hearing, the regulation that's cited in the order restricting us to the record is California Code of Regulations, section 1364.30. And as I read that, it says it applies to the panel of the board that issued an order of, quote, non-adoption or reconsideration, end quote, and does not apply to arguments after Superior Court remand. So there's a threshold issue here. We have a decision. The only decision I'm aware of is the one that revoked Dr. Tran's authority to practice medicine, and that was set aside by the Superior Court judge. The first question is, do we even have a decision at this point to modify? And the second question is, in light of this regulation that I just quoted, are we going to be restricted to the evidence of the record only, or can we offer post-hearing evidence of rehabilitation? Which is important in this case because the hearing took place more than 2 years ago, back in October 2020. And at that time, the panel will recall from this reading of the written argument that we submitted what the board had to say about the evidence of rehabilitation presented at that hearing more than 2 years ago. Quote, this evidence does not show that respondent has transformed himself. It only shows that respondent is beginning the process of transforming himself. Now, that assessment was made more than 2 years ago. So, again, I want a ruling respectfully on the scope of this proceeding, Your Honor.
Mr. Garcia, I'm not going to be making any rulings right now. You can make your arguments and make your record as you choose to do it. Again, I'm just going to admonish everyone that no new evidence will be considered at this hearing under the rules, but you can certainly make your arguments to the panel. I'm not going to be making a ruling on that threshold issue now. You may proceed. Your time is continuing.
It is continuing, Your Honor, but I just quoted that regulation. It does not apply to arguments after remand. Clearly, it only applies to non-adoption and reconsideration. So are you still ruling that I'm limited in the scope of this hearing?
Mr. Garcia, you can make the argument if you choose to use your time to make that argument. However, I'm going to be enforcing the rules that have been set by the board to hear this matter today. So please proceed with that in mind. Thank you.
Going to the Superior Court again, but I will. Okay. Here we go. The record evidence of rehabilitation. Dr. Tran testified that he accepted responsibility for his misconduct and he expressed remorse for having engaged in it. Factual finding numbers 16 through 20. In factual finding 18, the board states, quote, as an accurate summary of sentiments about his behavior and his acceptance of responsibility, respondent referenced a letter he wrote to the sentencing judge in the federal criminal case. In this letter, he acknowledged that his conduct defrauded the California healthcare system of millions of dollars, hurt his patients, the community, and his family. I quote an excerpt, a very brief excerpt from that letter. Quote, I participated in widespread abuse of the American healthcare system by compounding pharmacies and other service providers. I devoted my early career to helping people, so the truth of my crime fills me with despair. The anti-kickback laws are there to protect people, and I broke them. I took advantage of the healthcare system to enrich myself. I failed the people of California, the medical profession, and my own patients. I am remorseful and ashamed of the decisions I made. Others suffer because of my bad choices. I have lost many nights of sleep, tormented by the pain I have brought about into my community and my family. I will spend the rest of my life trying to make amends, quote, end quote. The record shows that Dr. Tran successfully completed the Professional Boundaries and Ethics course at the University of California Irvine School of Medicine. He testified that he learned not just from the course, but from introspection during the last 4 years. That was 4 years at the time of the hearing, 2 years ago. How to identify the stressors that led to his aberrant behavior and how to deal with those red flags should they resurface. Dr. Tran testified about his renewed religious faith and his volunteer work at a Buddhist temple. His testimony was confirmed by the Reverend Punyarisi for the benefit of the court reporter P as in Paul, UN as in Nelly, YAS as in Sam, IRI, who testified as a character witness. Reverend Punyarisi testified the respondent had been honest with him about his criminal conduct and had acknowledged his misconduct. He also testified that respondent has been an active member of the temple community and has contributed materially to its maintenance and development. In addition to his testimony, Reverend Punyarisi also wrote a letter on respondent's behalf, which was consistent with his testimony at hearing. Habib, H-A-B-I-B, Aki, A-K-I, also testified as a character witness, and Mr. Aki was a fellow law student of respondent and worked as a paralegal. He testified that, in his opinion, respondent is a person of honesty and integrity. He also submitted a letter that was consistent with his testimony at hearing. In addition to character testimony, Dr. Tran offered in evidence several letters of support, all of which attested to his transformational work in correcting the course of his life that led to his criminal conduct. The authors of those letters share their beliefs that Dr. Tran is, in his core, fundamentally a man of honesty and integrity, and that his criminal behavior was an aberration from what has otherwise been a life of service, integrity, and generosity. Now, at this point, I had planned to review post-evidence hearing of rehabilitation, and by the way, I want the record, I want a confirmation on the record that I did submit additional letters and attachments regarding Dr. Tran's post-hearing evidence of rehabilitation. May I have a confirmation of that, Your Honor?
I'm sorry, may you have a confirmation of the additional letters?
Of the submission of written evidence of rehabilitation post-hearing that was attached to a written argument.
That is correct. I saw that it's attached to your written argument, but that's not evidence that's part of the current record. That would be new evidence, and I've already explained that that is not something we can consider at this juncture. So I'm not going to permit discussion of those.
Your Honor, I understand that. I just want the record to be clear that I did submit additional evidence which is being rejected by this tribunal. That's all I wanted. You've confirmed.
Yes, you have the confirmation. You submitted it attached to your brief. And yes, I'm not permitting you to discuss those because they are not part of the present record, and we cannot consider new evidence at this oral argument. Correct. And you may proceed. You still have approximately 5 minutes and 30 seconds left. Thank you.
Now, the board has promulgated regulations for evaluating the rehabilitation of a licensee who has been convicted of a criminal offense. That's in California Code of Regulations, Title 16, Section 1360.2, Subdivision A, 1 through 5. I have referenced those in the written argument. I don't have the page numbers at the moment, but I did reference each of those criteria that have been promulgated by this board to evaluate rehabilitation. Notable among those criteria, which Dr. Tran has met, are the following. Number one, Dr. Tran has acknowledged the severity of his misconduct. Number two, there is no evidence of any criminal behavior subsequent to the offenses alleged in the accusation. Number three, the offenses occurred between 2013 and 2016. No other misconduct has taken place in the 6 years since the last alleged incident in 2016. Number four, respondent has complied with all terms and conditions of his criminal probation, and his motion for early termination of probation has been granted and has been released from any more supervision by the criminal courts. Number five, as previously summarized, Dr. Tran has undertaken considerable efforts to rehabilitate himself, including the completion of relevant continuing education courses, such as the ethics course at UC Irvine School of Medicine, spiritual spiritual renewal through his involvement in a Buddhist temple, his volunteer work, his cooperation with state and federal investigations, which actually led to the granting of his early termination of probation, and his earning of a law degree since the time of the, well, that's not evidence that you can admit. He was in law school at the time of the hearing. All right. Once again, these are the regulatory criteria that the board itself has promulgated for evaluating the rehabilitation of a licensee who has been convicted of a criminal offense. And the record shows that Dr. Tran has met that criteria. So what is the appropriate discipline? Business and Professions Code, Section 2229, Subdivision B, provides guidance on the appropriate measure of discipline. It provides the standard by which to appraise all the facts and circumstances of a case in order to determine whether revocation is truly the only means of protecting the public. While protection of the public is to be given high priority, the legislature has also decreed that, in exercising disciplinary authority, action calculated to aid in the rehabilitation of the licensee shall be taken whenever possible, and that it is only in those situations where rehabilitation and protection of the public are inconsistent and incompatible that protections such as a drastic measure of revocation shall be paramount. There is nothing in this record to indicate that rehabilitation and protection of the public are irreconcilable in this case. Instead, the evidence of rehabilitation militates against revocation and, to the contrary, supports disciplinary action calculated to aid in the rehabilitation of Dr. Tran. And in considering the appropriate penalty, consideration should also be given to the fact that Dr. Tran's medical license remained suspended for more than 6 years, and that suspension was ordered by the criminal court at the behest of the board. So he's already been through 6 years of suspension, and you must consider that as factoring into the appropriate penalty in this case. An appropriate measure of discipline would be probation on whatever terms and conditions the board deems necessary for protection of the public. You've heard this before.
You have 1 minute left, Mr. Garcia, just as a courtesy warning. Thank you. Go ahead.
Thank you. Well, you've heard this before, Your Honor. Rehabilitation is, quote, a state of mind. And the law looks with favor upon rewarding a person who has achieved the reformation and regeneration. The evidence demonstrates that Dr. Tran has transformed his life, and that as a result of the harsh lessons he has learned during the past 4 years, he is not likely to reoffend. Thank you very much.
Thank you very much, Mr. Garcia. All right, Mr. Ahn, are you ready to make the Deputy Attorney General's opening argument? All right, your time begins now. Thank you so much. Oh, sir, I believe you're muted, or I can't hear you.
I'm sorry, Your Honor. Can you hear me?
I can hear you now. Thank you so much. I will have you start over your time now that we can actually hear you. Thank you so much. Please begin.
Thank you. Profits over patients. That's what this case is about. Instead of providing honest, ethical medical services as a doctor licensed in California, respondent chose repeatedly place profits over patients. How many patients? 1, 2, 5, thousands of patients. Thousands of patients. When is the last time this panel has heard a case involving thousands of patients? How often does that happen? What was the total value of fraudulent, dishonest claims? $100? $1,000? $10,000? Millions of dollars. Millions of dollars. Given those facts alone, the appropriate discipline in this case is revocation of license. Contrary to Mr. Garcia's argument that there's a threshold question, the only question before the panel is, what is the appropriate level of discipline in this case? And the only appropriate answer is the same discipline proposed by the administrative law judge after hearing all of the evidence in this case. Page 38 of the proposed decision. It states, paragraph 22, that the administrative law judge, after considering all the facts in the case, the medical board disciplinary guidelines, the evidence of, quote, rehabilitation, and the record as a whole, the ALJ determined that the only disposition that would ensure public protection is revocation of respondent's license. He says, quote, this conclusion is reached for these reasons. Respondent's criminal conduct was serious, widespread, pervasive, and occurred over a notable time period. His criminal scheme involved multiple actors, multiple locations throughout California, efforts to conceal his criminal conduct, patients whose care was determined based on the monetary reward that respondent and his co-conspirators received, and a cost to the California healthcare system of millions of dollars in damages. So again, it's refreshing. It goes without saying that insurance fraud is a very serious violation of trust of a patient by his or her doctor. Sending patients for unnecessary medical treatment to increase the amount of insurance billing causes harm to the patients, insurance companies, and the general public, as well as constituting a serious violation of trust between the doctor and the patient. It is also worth noting that no other profession passes so completely within the power and control of another, as does the practice of medicine. The doctor-patient relationship is built on trust. By respondent's conduct, he violated the trust numerous patients placed in him when respondent placed his own financial interests before their care. Considering the severity of the crimes he committed, it was incumbent on respondent to present compelling evidence that he is rehabilitated and can now maintain his medical license. Such a conclusion cannot be made based on the minimal evidence of rehabilitation he presented. This evidence consists of his work at his temple, his religious faith, some volunteer work he has done, his completion of an ethics course. This evidence does not show that he has transformed himself. As an aggravating factor in favor of the most severe level of discipline, respondent has not participated in therapy or counseling to address the gambling addiction, alcohol abuse, or PTSD that he claims led him to involve himself in insurance fraud. In addition, respondent did not fully acknowledge his misconduct. He suggested he was less than a central player. Such a view is incorrect according to the factual basis of his criminal pleadings. He was the ringleader, the shot caller, the boss. He was telling people what to do, how to do it, that they can make money and place profits over patients. Additionally, his initial statement at the trial that there were no victims of his conduct suggests that he does not appreciate the true gravity of his misconduct. Respondent deflected blame for his conduct when he appeared to criticize the Deputy Attorney General, who was prosecuting the matter, for not allowing him to volunteer as a doctor at the border and to agree to lift the PC-23 prohibition. Respondent seems to not accept the seriousness of his misconduct or the consequences of it. The Deputy Attorney General represents the complainant, and for the purposes of the PC-23 matter, the board. The Superior Court, not the Deputy Attorney General, decides whether or not to lift or modify the restriction. Respondent has not provided any meaningful evidence of rehabilitation. He claims that his gambling addiction, lasting over a 12-year period, 12 years, which according to him was an all-consuming obsession. The gambling addiction was an obsession for him, which is what allegedly led him to commit the crimes in question. And when I asked him at the trial, did you receive any treatment for the addiction? The answer is no. Okay. And respondent also abused alcohol on a daily basis in a controlled 2 substance on a daily basis, hydrocodone, without a prescription. When I asked him, how did you obtain the hydrocodone, sir? And his answer was essentially, well, I just grabbed what's left over from the inventory. No prescription, no medical indication. Did you receive any treatment for the alcohol? No. 2 sessions of Alcoholics Anonymous, and he decided that it was not a good fit. No attendance of Narcotics Anonymous, no therapy, no counseling, no treatment whatsoever. And he wants us to believe that voila, 12 years of gambling addiction, he can wake up one day, wish upon a star, and it goes away. Poof. Now, is that consistent with what the members of the panel know about addiction and how it works? As part of his character evidence, he called his law school friend as a witness, not realizing that that almost got him into more trouble. The law school friend essentially testified that even though this was a time period when respondent was prohibited from practicing medicine pursuant to this order from the Superior Court of San Diego, that he was essentially doing just that, giving medical advice to his law school teacher and others about what to do about the medical condition and or suffering. And then they realized, well, that actually is bad evidence. Let's not emphasize that. The problem is that respondent does not even seem to understand what counts as good rehabilitation evidence. He thought that was helpful. He thought calling a monk was helpful, that they sat around and prayed and meditated, and that should forget everything, that everything just goes away. Given the gravity of the misconduct involved, even if we set aside the criminal convictions, the underlying conduct of fraud, deceit, insurance fraud, workers' compensation fraud, none of that goes away. And because of the magnitude of the fraud in thousands of patients, the efforts to conceal his wrongdoing, respondent admitted that he took specific steps to conceal his tracks, setting up shell companies, calling them marketing services, when in fact there were bribes used to buy and sell patients like commodities. Coded messages. Over 25 individuals involved in this conspiracy. Over 20 office locations. Over a 3-year period. And respondent admitted that he grabbed it by the horns and ran with it. He was not a passive, low-level participant. He was an active, supreme godfather of the organization, calling the shots. Let's grow this thing. Let's make millions. Let's defraud victims of millions. Because there is no victim, according to respondent. The only appropriate level of discipline is revocation of respondent's license. Thank you.
Thank you very much, Mr. An. All right, Mr. Garcia, you have another 5 minutes for a rebuttal argument. And I just want to make sure that the record is clear too. I'm not precluding you or any party from making arguments about what you think the scope of the remand is or what you believe legally should happen on remand, but I am precluding the discussion and consideration of new evidence. If at some point the board believes your legal arguments are persuasive, then perhaps that can be permitted at a later point. But today, no discussion of evidence outside of the record or new evidence. But you're certainly welcome to make your legal arguments as you have been. I'm not precluding that. And of course, Mr. An can respond to that. So with that being said, you have another 5 minutes for a rebuttal argument. Mr. Garcia, are you ready to proceed?
I am, Your Honor. Thank you very much. So
Thank you very much. Go ahead.
I will go back to my argument then on why I believe that the scope of this proceeding is inappropriate. Again, the admonition in the order of the board regarding the scope of the hearing, it says written and oral argument are to be limited to evidence contained in the record, citing that regulation that I previously referred to. But if you look at that regulation and read it, it says it applies to arguments presented to a panel of the board that issued an order of non-adoption or reconsideration. This panel didn't issue those orders. This was a remand for the Superior Court on a judgment setting aside a decision that revoked Dr. Tran's license. And once again, the hearing in this case took place more than 2 years ago. This gap in time is crucial here because one of the principal reasons underlying the decision to revoke was what the board then perceived to be lack of a sustained period of rehabilitation. So again, that assessment was made more than 2 years ago, and respondent has continued the process of transforming himself during this span of time. And for that reason, and because that code section, the regulation does not apply. And finally, because the question before the panel is whether the board's disciplinary order calling for revocation should be modified, a question that necessarily encompasses consideration of the essential issue of rehabilitation. Respondents should be permitted or should have been permitted to present additional evidence of the rehabilitative efforts he has undertaken during the 2+ years since the hearing took place. Okay, now, Mr. Tran, I'm sorry, Mr. An, spoke about the severity of the offense. Absolutely correct. It was a severe offense, and Dr. Tran has never said otherwise. He's acknowledged the severity of the offense. And again, Mr. An quoted from the ALJ's decision issued more than 2 years ago, referring to the minimum evidence of rehabilitation. And again, Your Honor, this is additional reasons why the post-hearing evidence of rehabilitation is necessary. So it's not only necessary, it's fair in arriving at an appropriate penalty. What has Dr. Tran been up to since that decision 2 years ago? Has he undertaken additional rehabilitative efforts? That's the question, and I think that evidence should have been permitted in order to arrive at a fair and appropriate penalty in this case. Let's see here. Now, in concluding, I think it's remarkable and notable that Mr. An did not refer to the criteria in the regulations promulgated by the board for the evaluation of rehabilitation. He went back to the decision and, said that it was terrible evidence of, the misconduct, which Dr. Tran has acknowledged, which I've acknowledged in my comments as well. But let's look at the criteria. I mean, that's what it's there for. The board promulgated those regulations. Here's what we look at. We're going to assess rehabilitation point by point, and I've already gone through them. And that's what you look at. And then you go to the record and you make a determination whether the evidence that we presented on rehabilitation comports with that criteria for rehabilitation. And if it doesn't, a determination of rehabilitation should be made. But I think it's
You have
notable
1 minute remaining. Thank you, sir. Go ahead.
It's notable that Mr. An did not refer to those factors that must be considered in evaluating rehabilitation. With that, I'll conclude my remarks by stressing once again that I think that we've been denied a fair proceeding by curtailing the scope of the hearing to the record evidence and precluding evidence of post-hearing rehabilitation. Thank you very much.
Thank you very much, Mr. Garcia. And then Mr. An, you have another 5 minutes for your rebuttal argument. Are you ready to proceed?
Yes, Your Honor.
Thank you. Please, you can start.
Thank you, Your Honor. Regarding the scope of the argument and this hearing, Mr. Garcia is almost mimicking his client. He's trying to change the rules at the last minute. The rules are clear. This hearing is limited to the record that we have. And the Superior Court's order only discussed the portion of the decision involving the criminal conviction. It did not even address the other causes for discipline, which was proven by clear and convincing evidence that respondent engaged in dishonest and corrupt acts, that there should be discipline based on the insurance fraud and workers' compensation fraud, and that he committed general unprofessional conduct. The case was remanded for reconsideration by the board, which is why we're here today. And we're confident that whoever is looking at this issue will find it moot, that we are held to the administrative record, and that is what is fair and reasonable in this case. Otherwise, the respondent will have an opportunity to introduce evidence that was not before the ALJ at the time of the hearing, and then essentially playing Monday morning quarterbacking and criticizing the decision as incomplete or inaccurate or wrong. That's not fair. So we're limited to what was heard and presented at the hearing, and that's true for both parties. Regarding the criteria that Mr. Garcia relies so heavily upon, well, first of all, that criteria refers to the criminal conviction. Since the judge set aside the criminal conviction portion of the decision, that's why there's no need to discuss the criteria. And even if we were to discuss the criteria, the facts do not help respondent. The fact that he went to law school, for example, how is that relevant or helpful for respondent? That he now knows the law better, so he can commit more crimes and let her get away better this time? Let's focus on the medicine. Respondent has not even made any effort to keep his skills sharp as a licensed physician in the state. He took one ethics course, while doctors who are practicing now, doctors who have been practicing for years, doctors with no blemish on their record are required by the board to complete continuing education courses every year. Respondent who has not been practicing medicine since 2016 has completed one course and thinks that that's sufficient rehabilitation, sufficient preparation. The Superior Court of San Diego County concluded that even though respondent had not been convicted of any crime at the time, concluded that it, based on the interest of public protection, issued an order prohibiting respondent from practicing medicine at all. That was 2016. Respondent appealed. A panel of appellate judges at the appellate court agreed with the Superior Court and said, even without any conviction whatsoever at that time, respondent was deemed too unsafe to practice and upheld the Superior Court's PC 23 order. The medical board, the Attorney General's office, Superior Court, Appellate Court, everybody agrees respondent is unsafe to practice, and the only person who disagrees is respondent and his attorney. With no rehabilitation evidence, severity of the conduct, thousands of patients, millions of dollars of losses. The only discipline justified and justifiable is revocation of his license. Thank you.
Thank you very much, Mr. On. All
Your Honor,
right.
I'd like to pose an objection, please.
What is your objection, Mr. Garcia?
What's good for the goose is good for the gander, and Mr. Ahn has made comments that are outside the record, including comments about appealing the appellate process following the issuance of a restricted order by the Superior Court. That's not in the record, and so I object to that part of it.
All right, Mr. On, your response?
Yes, Your Honor. That is in the record, the PC-23 order, as well as the order of the appellate court denying respondents' petition to overrule the Superior Court.
All right, objections overruled. Thank you very much. Mr. Garcia, would you like to have your client address the board?
Yes, Your Honor.
All right. Dr. Tran, if you could just unmute now, and can you still hear me well, sir?
Yes, I can, Your Honor.
Terrific. Thank you so much. Dr. Tran, the first thing I'm going to do before you address the board is to raise your right hand and I'll swear you in, okay? Do you solemnly state under penalty of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Thank you so much, Dr. Tran. You can put your hand down. And this is your opportunity to address the board in support of the oral arguments of your counsel. Anything you believe that is appropriate, you're welcome to give it. Again, I'll just admonish everyone that we are limited to the record as it presently is. No new evidence can be presented. With that said, you have the floor, Dr. Tran. Thank you so much.
Well, thank you, Your Honor, and thank you, the panels of California Medical Board. Time change a lot of aspects in life. Time change my mindset. Time change my behaviors, and times do change my person. I remember when I was a 13 years old boy, travel on a boat to come to America for 30 days without food and water. 25 people died out of 50. It changed me from a person that has nothing, came to this nation and become a professional. Once I become a professional, I made a big mistake in my life, the biggest mistake ever. And I accept the full responsibility for what I did. I deeply regret and very remorseful for all of my actions. I tried to redeem myself. I took upon myself to take an ethics course at UCI in ethics and boundary. I changed my mindset with a spiritual renewal, learning the different aspect in life that would help me to become a good person, a better person. I cooperated with the state and federal investigation because I know what I did was wrong, and I want the system to know other people that is wrongdoing should be responsible for what they did. I went to school and got a law degree from Pacific Coast University, not because I want to be a bad person, but I wanted to learn to know my boundaries and to understand the law so that I will not be involved or be a part of anything that is illegal and is not good for the public and is not good for a person. I work in the law firm, and I volunteer at the two nonprofit organizations, the Golden Hearts Foundation and the Asian American Senior Citizen, using my skill and knowledge to contribute to the society. I comply with all the regulations for the past 2 years, including drug test. I do not use any more alcohol, and even a condition on my probation was not to gamble. And I have proven myself that it's been 100% comply with all the requirements from the probation. The offense that I committed was back in 2013 and 2016. It's been 6 years, more than 6 years now. Every day I think about what I did, and I have there's no blaming. I'm not blaming of the PTSD. I'm not blaming that I doing this for whatever reason. I accept the full responsibility. This is wrong. What I did was wrong, and I learned from it since my conviction. I have participated in numerous organizations, nonprofit organization, and comply with all the conditions on my probation. And since I got my license back on or about September last year, 2022, I used my skill, and I got it back because I took more than 50 hours of CME credits that is required by the California Medical Board to continue to have my license valid. I did that, and I know that's the rules and regulation, that I sharpened my skill. And even that, I don't practice full-time. Now I'm using my time to study for the bar exam and help out at the nonprofit organization to help the senior, to help the homeless people.
Your Honor, I'm going to object. Dr. Tran is introducing new evidence outside of the record.
Mr. Garcia, your response?
Well, he is. Yes, he is.
All right, I agree. I just wanted to give you an opportunity. I never want anyone to be deprived of an opportunity to respond. So yes, I will just again instruct you, Dr. Tran, this hearing, we are not allowed to consider new evidence at this juncture. So, and I'll instruct the board members to disregard any new evidence that's not presently in the record. So with that admonition, you can continue your statement, Dr. Tran. Thank you.
Yes, Your Honor. So,
I'm sorry, Mr. On, did you have something else to say?
Yes, I'm sorry, Your Honor. We move to strike the testimony that is outside of the record.
Motion to strike is granted. Thank you. You can proceed, Dr. Tran.
Thank you, Your Honor.
So in closing, Your Honor, and the panel of California Medical Board, basically I made a biggest mistake in my life. I'm ashamed of it. I'm deeply remorse. I was sorry for the fake success that ended with my poor judgment. And I'm just determined for the rest of my life to become a better person that is worthy of forgiveness and redemption. And Your Honor, the panel of Medical Board of California, I will never return to the court system for any action similar to what I did. And that's something that I know, because time do change. It changed my mindset, it changed my behavior, and it changed me as a person, Your Honor, in the panel of Medical Board of California. Thank you.
Thank you very much, Dr. Tran. All right, now I want to give our board members an opportunity to ask any questions of either counsel or Dr. Tran since he's here. I'm just going to start down the row. Dr. Thorpe, do you have any questions for counsel or Dr. Tran?
Thank you, Your Honor. I do have questions, but I'd like to defer to my panel to allow them to ask questions first. I prefer to have them ask the questions, and then at the end, if my questions are not answered, I'll be happy to proceed. Thank you.
Absolutely, no problem. Next, I have Dr. Hielzer. Do you have any questions for counsel or Dr. Tran?
I have no questions. Thank you, Your Honor.
Thank you very much. Let's see. Ms. Lawson, do you have any questions for counsel or Dr. Tran?
I have no questions. Thank you, Your Honor.
Thank you, Ms. Lawson. And then Dr. Mahmood, do you have any questions for counsel or Dr. Tran?
Yes, I do have a question for Dr. Tran and counsel. Um, Mr. On brought a very important point that you went through such a huge challenge, and that did affect Californians, that did affect people we are here to protect. And in all this time, we don't have any evidence that you went on to get any counseling, any rehabilitation, which is out of the thing. Do you think that you are strong enough to understand everything by yourself, or just taking one course in some university about ethics and you will just be fine? Because everything else on this part, everything is taught in medical school and training anyway. So is there any excuse you have for that, or anything we are missing on that part?
Yes, Dr. Mahmood. I did went to, I know that gambling and alcohol is a contributors to my mindset and contributed to my wrongdoing. I did went to a course that is involving the AAA, Alcohol Anonymous. I went there a few times for treatments, and I do appreciate the environment where people are sharing the experience so that they learn the red flags and the triggers. I did went for those courses, and as far as the additional courses beside ethics boundary from UCI, I basically look up to people in a society that is considered as leaders that I share my experience with, and people including politicians, including the reverends, including professors, and including leaders in the community who I work with at the Golden Heart Association and the Asian American Association, as well as the community leaders and the politicians as well. They're all aware and know of my convictions, and I seek out for help from the leaders. So with all of those factors that I used to help me to change my mindset, my behavior, and change me as a person. So there's a lot of people that I owe this to, Doctor, and I will continue to do this. And for the past 2 years on my probation, which restricted me from, they do the drug test pretty frequently, maybe every few months or so at random. I never consume alcohol no more, and I never consume any drugs no more, and I never did any gamble anymore. So I feel with that I'm comfortable that I'm out of those factors that basically led up or contributing to my bad behaviors. But I will continue to learn and continue to if I recognize any red flags or triggers that will basically potentially can put me back in the similar situation like before, I know now to recognize them, and I do have a more supportive people around me now that I can look up to and get help from.
I'm gonna object to the portion of the testimony dealing with any subject matter of evidence outside of the record, and I move to strike that portion of testimony.
He was responding to.
I'm sorry, Mr. Garcia. I just want to make sure, Mr. On, were you done with your statement?
Yes, Your Honor.
Thank you very much. Now, Mr. Garcia, do you have a response?
He was responding to a specific question asked by a panel member, so
Yes,
I don't think it's appropriate.
All right, well, I appreciate that, and I'm going to grant the motion to strike again any evidence that's outside of the record at present. And I'll just instruct again our board members as well that any of your questions have to pertain to evidence that's already part of the present record. I know it's hard to sometimes tap into that, but that's what we're limited to in this proceeding. So thank you very much. Dr. Mahmood, do you have any additional questions?
That is, I'm okay now. No more questions.
All right, thank you so much.
Thank you.
Dr. Thorpe, then I'm back to you. Did you have any additional questions for either the council or Dr. Tran?
Yes, yes, Your Honor. Thank you very much. My question is also for Dr. Tran. Dr. Tran, as a trained physician, and my understanding is that your training was in anesthesia and pain management, and that was, the extent you had an extensive practice in multiple locations where you were providing services. But you, of all people, understand the power of addiction in chronic narcotics and chronic use of medications, and it is troubling to me. I certainly believe in the power of redemption, and I certainly believe in spiritual transformation, and I want to be fair and careful in my judgment, but it is troubling to me that in an addiction where you weren't just gambling hundreds of dollars, you were gambling to the point that you had millions of dollars, or up to $1 million. I don't know exactly how much, but it was the sum of $1 million was at least once alluded to in terms of how much you were in debt to whomever, and certainly I can see with that kind of financial obligation why it would encourage you to continue on this abnormal course, and yet you still have not sought any professional help in dealing with addiction. And I just want to make sure that I am understanding that clearly, that there is no history of, I know you went to AA a few times, which is admirable, but you basically said after a couple of sessions, my understanding, that it wasn't for you. And so I don't know that 2 sessions with AA really kind of stands up. My question really is it true that you did not seek professional counseling for your addiction and your addictive behaviors, gambling and alcohol? And if it's true, why did you not seek it as a trained medical professional?
Yes, Dr. Thorpe, as a trained professional, we all readily, heavily relies on our mindset and our ability to absorb the information coming to us and learning to change. For me, learning to change to deal with my addiction was reading book about addictions, reading how to avoid alcohol, how to avoid gambling, and talking to the leaders in the community, talking to the people I look up to. And that was appropriate for me. And like you say, I did went to the Alcohol Anonymous a few meetings, but I feel like that's not how it fits me. I learned by the books, but I learned by reading. I learned by talking to people who I look up to as the leaders. And I can basically tell you that it's been 6-7 years now, ever since my conviction. I'm clear from my addiction from alcohol. I don't drink it, and I don't gamble, and basically, it's kind of hard to believe to a regular person that they need to have a professional help. But for me, what works for me is to realize what I did and realized the contributing factors that basically led up to my bad behaviors, to my convictions, and basically internalize it in my mind with time, with the right people, with the right leaders, and that was enough for me. And I can tell you that I've been tested with blood, with urine, during my probation, and there was no zero violation.
Extraneous evidence that Dr. Tran is introducing. Once again, move to strike any testimony or any evidence that is outside of the administrative record.
And Mr. On, is that objection specifically as to the evidence that he testifies to as to current compliance with probation and testing for biological fluids, etc.?
Yeah, and the current alcohol habits, the current gambling habits, etc.
All right. Any response, Mr. Garcia?
Well, no, we according to your ruling, no. What can I say? You've ruled already that we can't refer to anything post-hearing, so I'll submit it, Your Honor. It's up to you.
Thank you very much, Mr. Garcia. Again, motion to strike is granted. Just to clarify, again, so make sure we are sticking to the evidence in the current record, just to clarify Dr. Thorpe as well as Dr. Mahmood's question. So based on the record before us, the evidence that's currently in the record, Dr. Tran, the formal treatment that you've received for gambling and the alcohol and other substance use consisted of I think it was 2 AA meetings you attended, as well as I think you said reading books and speaking to other mentors, etc. Is there any other formal treatment, just to make sure we're clear on answering both board members' questions, that's currently in the evidence that we haven't addressed?
Yes, Your Honor. I guess whatever form of treatments as a physicians, the outcome is what we should measure. And Dr. Thorpe, I have shown and basically clear from alcohol and I'm clear from gambling addictions. However, if you and the board feel that I need to show myself by mandating me to take a course, I have no problem with that. Whatever that you feel is appropriate and comfortable to have a complete transformation, I will abide by that, and I have no problem with cooperating. And because I know the end result is to protect the public and to do what's right. And I know your concern as a physician. I want to be clean and I want to be 100% ready when I'm dealing with patients, when I'm dealing with publics, that I will use all of my training, my background, my ability, because that's what I love to do. I love to help and I love to be a doctor. Learning from law school basically will help me a lot too, as to know the boundaries, know exactly what I should not do and know the things I should do. So like I say, I'm a change person. And if it takes more to change me that is required by the board, I'm very happily to comply with it.
Thank you, Dr. Tran. I want to be clear, my question isn't directed, I'm not suggesting anything, that's up to the board to determine. I wanted to make sure, because there's been a lot of back and forth from the lawyers about the scope of the evidence, I wanted to make sure you had an opportunity to emphasize any evidence that's currently in the record of formal treatment for your alcohol and gambling issues. And I just wanted to make sure you had an opportunity to emphasize any of that you wanted in response to the board members' questions. I'm not suggesting anything as to the outcome of this matter, one way or the other. So I'll take it back to Dr. Thorpe. I'm not sure if Dr. Thorpe has any additional questions. Dr. Thorpe?
No, Your Honor, I have no additional questions.
Thank you so much. How about any of the other board members? Any additional questions occurred to you since I last asked? Please feel free to pose them. All right, I don't see any additional questions from the board members, so thank you very much. I believe that concludes the proceeding for today, concludes the arguments in this matter. Then the record is closed, the case is submitted for decision, and we are off the record in this matter. The panel will be deliberating in a closed session. I'll turn it back over to you, Dr. Thorpe. Thank you.
Thank you, Your Honor. Thank you, Counsel Ahn and Garcia. Thank you, Dr. Tran, for your presence here today and for taking your time. We appreciate that a great deal. It was very helpful. The panel will now adjourn. Could I have a motion for adjournment? We need to go into closed session for deliberation. Been moved in second. Okay, we will adjourn.
Dr. Thorpe, actually, you can't adjourn till after the meeting, after the closed session. So we will keep this session open, and I'm going to head over and start panel A. Angel will be taking you guys through the 2 closed sessions. So we'll put up a message about the closed session happening here and leave it open for the public who wish to stay on until that does end. But you guys will want to look for the invite for the closed session meeting with the start time of 10:45 a.m. Obviously, we're behind schedule, but that 10:45 a.m. is your closed session for deliberations. And then at the conclusion of the deliberations, you have an 11 o'clock a.m. one for the remaining items. So you have 2 sessions to go to. So we'll see you over there, and Angel will be assisting with the rest of it. But we will keep this meeting open, and you'll have to return here at the end to adjourn. But only you have to return if the rest of the other members can't do it.
Okay, thank you, Sean. Appreciate your keeping me on the straight and narrow.
Thank you. So we'll go ahead and display that closed session meeting and make sure we get all the panelists over into the closed session. Any public attendees are welcome to remain here. But again, it is just adjournment following the end of the closed session. So we will keep it open, but you're welcome to stay if you like. Thank you very much.
Okay, we're back in open session for panel B for the purpose of adjournment. I think Dr. Helzer and I are the only people here. I assume we're in favor of adjournment, which we are. So we'll adjourn open session. Thanks everyone for your participation today and for your thoughtful preparations. The panel B meeting for February 8 is adjourned.